Hello and welcome to another episode of The Letter of the Law through Bloomsbury Institute London in conjunction with the London Legal Podcast as hosted by Hodge Jones and Allen Solicitors. Today we're talking about an important subject in the area of dispute resolution, one that might not easily strip off the tongue or be so obviously relevant, but if you're a business tenant or a business owner, it's of vital importance. The subject today is commercial lease renewals. And to talk about commercial lease renewals, I'm joined by Reema Chugh, a property and commercial dispute resolution solicitor and an accredited mediator at Hodge Jones and Allen. Reema, welcome.
Thank you, Saurav.
Now, just before we launch into the subject of today's conversation, remind our listeners, what do you do day to day?
So I specialise in property and commercial disputes, so commercial landlord and tenant disputes, service charge and lease breaches, forfeiture issues, dilapidations, break clause disputes, neighbour building disputes and contractual fallouts, usually between businesses. So in practice, what that includes is landlords who want to make decisive decisions about their commercial units, tenants who want to protect trading premises, and businesses who need disputes resolved without losing months and time of energy. Often the real goal in these situations isn't about winning, it's getting back to normal life. And I'm also an accredited mediator, as you mentioned earlier, meaning that I aim to act neutrally, helping parties find resolution without going through the court process.
Thank you. And just before I go into the firm itself and a bit of history about it, what about you as a person, Reema? What do you like to do outside of work?
Oh, outside of work, I actually do exactly what I'm doing now, listen to podcasts.
Okay. What sort of subjects?
All on self-improvement, anything that's informative and that's something that I can learn from. I aim to listen to a podcast each day that can teach me something. So, most recently I was listening about agent AI, so that's for another day that we can talk about how the world is evolving.
Great. And as I mentioned, you're with Hodge Jones and Allen Solicitors. For listeners who aren't familiar with the firm and what they do, can you give us a brief rundown?
Sure. So Hodge Jones and Allen was founded in 1977 by Henry Hodge, Peter Jones and Patrick Allen. With a strong access to justice ethos, almost 50 years on, the firm has now grown significantly and we've been recognised in the Times Best Law Firms 2026 list. So that's great. We're known for fighting cases properly, but we're also practical. Mediation is a key part of that. It's often the smartest way to resolve disputes efficiently and commercially.
Thank you. So, returning to the subject of today, we're talking commercial leases. Reema, why do I feel like this is one of those things business owners ignore until it's far too late?
Yes, I do agree with you. And in my view, I feel that businesses usually ignore it until it's too late. And I would say most business owners are busy running their actual businesses. They're not reading the leases that they signed 10 years ago. And then suddenly the landlord serves a notice or they realise, the rent is about to jump.
So today, essentially, we are demystifying the subject. Is that right?
Absolutely. We're talking about when you have a right to renew, when you don't, how landlords try to increase rent, and what mistakes cost serious money.
Okay. So before we jump into commercial leases, I'd just like to remind listeners that if you have a question about property dispute resolution, about commercial leases, you'd like to make an inquiry and learn more about your legal rights in this field, then do get in touch with us. The phone number is 033 00 294 446, and you can email as well on bilradio@hja.net. So back to the subject of our conversation, Reema. We're talking about commercial lease renewals, and let's take it down to basic principles. What even is a commercial lease renewal?
Yes, I think we ought to start there, don't we? So in simple terms, it's what happens when a business tenant's lease is coming to an end and they want to stay in those premises. The key question is often, do they have a legal right to renew? And, it's the most basic question. And people automatically assume that either they can renew, or some actually assume the other end of it, which is they have to find somewhere else if the landlord asks them to. They don't know that in leases there is something called an automatic right to renewal. We'll come on to that later.
So the key question being, if individuals have a legal right to renew, what does that depend on?
Yes, so that's dependent on whether the lease is protected under the Landlord and Tenant Act 1954.
And if it is?
Yes, if it is, then it's inside the Act, and the tenant usually has a statutory right to renew the lease. But there is a big but. If it's contracted out, then they don't have that automatic right of renewal. So this is what I meant by when I said earlier that some tenants will get informed that by their landlord that they have to vacate the premises. Whether they're contracted into the 1954 Act, they will start looking. So it's important to know that you have a statutory right to renewal, or if you don't.
You used the words contracted out. That sounds quite sinister to me.
Yes, but it's actually not sinister. It's quite deliberate. Before the lease was granted, the tenant signs a formal declaration giving up their right to renew. And you see, a lot of businesses don't fully appreciate what they're signing at the time.
Okay. And why do you think that is? Why don't these business owners fully appreciate what they're signing at the time?
Lack of legal advice.
You would say that, wouldn't you? Okay.
It's actually the honest truth, because what happens in these situations is, I'll take an example of, let's say, a restaurant. What people are concerned with, the business owners, they just want to sign the lease, signed page, get it over with, do their fit outs, and start operating. But it's very important to actually read what you're signing, and it's important to know that you can opt out of the automatic right to renew, which the 1954 Act grants you.
Okay, so let's turn to landlords and their renewal rights, and specifically their ability to refuse renewal. If this right is protected, as we've just spoken about, can the landlord still say no?
Yes, they can, but it's very, very specific, limited statutory grounds on which they can deny the renewal.
Okay, so if the landlord seeks to refuse renewal, you've just mentioned specific statutory grounds. Could you speak about some of those grounds and what they may be?
Of course. Once I've stopped coughing.
It's okay.
Right. So, statutory grounds: persistent delay in paying rent, breaches of lease covenants, or the big one is redevelopment. If the landlord genuinely intends to demolish or substantially reconstruct the premises, they can oppose the lease renewal.
And these have to be rooted in reality, right? They just can't say that this is what's happening.
Exactly. It has to be genuine, settled intention. Courts look at whether the landlord actually has planning permission, funding, and a realistic scheme.
Okay. If you're listening and you're a landlord or a commercial tenant, and the issues that we're discussing are relevant to your situation, and you'd like to make an inquiry or learn a bit more, then please do so via a dedicated phone line 03300 294 446, or via email at bilradio, all one word, at hja.net. If you're joining us, we're speaking with Reema Chugh, a partner at Hodge, Jones and Allen Solicitors in their property dispute team, and the subject today is commercial lease renewal. Right, so let's turn to the subject of rent. This is where it gets interesting. The reason it's interesting is it's all about money, because that's what most people care about, isn't it, Reema?
Yeah, absolutely. Absolutely. So the new rent, usually when in lease renewals it's discussed, it's not just whatever the landlord fancies, it's actually assessed market rent. This is something that that's calculated thoroughly by a qualified surveyor that specialises in valuations of commercial premises in that area and their rent.
So if the area is improved as a result of these changes, the tenant pays more?
Potentially, but you see, there is an interesting bit. The tenant's improvement, if they're disregarded. So that's the key point.
Hang on a minute. You just said tenant improvements are disregarded. What does that mean?
So if the tenant has made the premises more valuable, for example, by installing a high-end fit out, or the landlord doesn't get to increase the rent because of the tenant's own investment. So what happens is, say for example, just to apply that in practice, again going back to the most basic, a restaurant, the tenant goes in, does a very nice fit out, and what happens is the value increases. So the landlord just doesn't get to increase the rent because of that fit out, what value that's added to it. You've got to look at the premises and disregard the improvements made by, or the additions made by the tenant.
Okay, that feels fair.
Yeah, it's one of those more balanced parts of the legislation, I would say.
Okay, so we're talking, obviously you're a lawyer, we're speaking about commercial leases, and legal advice is it's running across this whole conversation, and therefore strategy is vital and timing is everything. With that in mind, when should tenants start thinking about renewal?
I would say this is the most important part. They should think about it at least 12 months before expiry, ideally earlier, because the sooner you start thinking about it, the sooner you can get the ball rolling, the sooner you can enter negotiations, and the better you can prepare for your business without incurring any financial losses. If worst case scenario, you cannot continue with the same premises where you are.
Right. So let me put my landlord hat on. If I'm, my tenant hat on, if I'm looking at this renewal process and you're saying 12, 15 months before expiry, even earlier than that, the question I might be asking then is why so early?
You see, this is because once a formal notice is served, whether that's a section 25 or 26, the clock starts running. And missing deadlines, you can easily lose your rights entirely. So it's one of those most important parts of the legislation that you've got to, when you're looking at renewing, or as a tenant, if you're looking at renewing, you've got to serve the Section 26 notice. As a landlord, if you're looking to grant the renewal, then you've got to serve the Section 25 notice, or otherwise, if you're looking to take away that right, you've got to let the tenant know by serving a formal notice.
So this isn't a leave it until 3 weeks before expiry situation, is that what you're saying?
Absolutely not. That would be a disaster. I'm not saying that doesn't happen, but that's how people accidentally forfeit their protection, because once the lease is expired, you've lost your right, and if you've not come to some terms or served a statutory notice, then you've potentially lost your right to renew.
Okay. So are you a commercial tenant and you're listening to this, and what we're talking about is relevant to yourself or a loved one or a friend who is within a commercial property, then get in touch. The number is 033 00 294 446, and there's an email as well in case you'd rather write it all out. That's bilradio@haa.net. Again, if you're joining us today, we're speaking with Reema Chugh, a partner in the dispute resolution team at Hodge Jones and Allen Solicitors. The topic, commercial lease renewal. Now, Reema, we've spoken about this as well, but there are mistakes that are made by tenants and landlords. But could you talk about some of the common mistakes that take place within these scenarios that we've been speaking about? Give me your top 3 mistakes.
Interesting. I mean, there's so many mistakes that can that can take place during this process. But if I had to give you my top three, I would say number one would be not checking whether the lease is contracted out. We've already covered that. Ignoring notices because they look too technical. People receive them, they think, oh gosh, this is too much information. I've got to keep my business running. Let's put that to a side. A very big mistake. And the last one would be assuming the landlord's proposed rent is non-negotiable.
So negotiation is normal?
Absolutely, it's expected. You see in commercial leases, renewals are essentially structured negotiations under a strict legal framework. So these negotiations are absolutely normal.
Okay, let's bring all of this legal language to life in a real life scenario. Without naming names, Reema, what's a typical scenario that you see in your line of work?
Retail tenant, let's say, and lease is expiring. Landlord serves a notice proposing a 40% increase in rent. And what happens is often the tenant panics. But when comparables are properly analysed, the market doesn't support that figure. So it's advisable, again, and going back to my point, is do not ignore the notice and don't think that what the landlord has proposed is non-negotiable.
So it's about evidence?
Always. So surveyor evidence, as we touched on earlier, is crucial in these lease renewals.
Okay. Let's turn to redevelopment. If the landlord wins on redevelopment grounds, does the tenant get anything?
Yes, actually. There's potential for compensation here, which is a statutory compensation, and that's based on rateable value and length of occupation.
Okay. So at least they're not just thrown out empty-handed, essentially. Yeah,
exactly. There is potential to get some compensation for the loss and inconvenience. And, what the legislation does, the 1954 Act, it tries to balance commercial certainty with business protection. So because you're losing that business protection, so there's got to be some compensation for it, and that's been recognised.
Okay. Now, if you're listening, you can pass along a question to Reema about the subject of commercial leases. You can do that via three methods. There's a dedicated phone line, which is 03300 294 446. There's an email at bilradio@hja.net. And there's our social media feeds as well, where you will find this number and that email on the chain of social media posts promoting this very show. So we are now going to turn to some questions, Reema, if you're up for it. Are you up for a rapid fire round?
Oh, exciting.
Right.
Just don't throw me too many questions and too fast, but let's give it a go.
How about I do the opposite? How about I make you sweat? Okay.
I think actually in this office it's quite warm already, so you've already missed that part.
Okay, well, look, these are some quick answers to some questions that we received from our audience, but by all means, don't feel limited to a one-liner. If you think it's worth expanding on, then please do so. Right, so here's a really difficult one for you. Really difficult one. Should business owners actually read their lease?
This is a tough one. This is very tough, like you said. But I would say this is a radical idea, not... yes, absolutely.
Okay. And is the reasoning that my landlord seems nice legal protection in itself?
No. But often you'd be surprised how many times people actually come and say... Yes, the lease is expiring. I haven't served any notice. The landlord hasn't served it, but I talk to him. I see him all the time.
So landlords are not all evil is the moral of this podcast. And is timing important?
It's absolutely everything. There's a lot to lose than you can ever think about in these situations. There's so many things that can go wrong if you wait till the end of the expiry of your lease. So yeah.
Now, you're a mediator. You love talking. You love coming to compromises and agreements. But is the subject of commercial lease renewal something people should DIY?
When it comes to these commercial leases, I don't have my mediator hat on unless I'm instructed in the capacity of a mediator. So, now we're talking about the legal framework or around commercial leases. And do I recommend with that legal hat on that people should do a DIY job? Absolutely not. Not if their premises matter to their business. Okay. No.
Some audience members have submitted a few questions, these are really excellent questions. They're a bit more technical on the side, though, Reema, if you're ready for them.
Yeah, let's not make them too technical, Saurav.
Okay, yeah, not too technical. Well, I blame those who submitted these. Okay, so this is about sustainable practices and green leases, and the question is, have you found that there's been a growing demand for more sustainable practices throughout the real estate sector?
Wow, that's a really interesting one. So thank you for that question, especially to the audience for sending them through. Definitely. It's not just a buzzword anymore. 5 or 6 years ago, sustainability would come up occasionally. But now it's part of almost every commercial lease discussion. And it's growing. It's growing. Investors care about it. Lenders care about it. Tenants care about it, EPC ratings and energy efficiency, long-term performance of the building. All of these things feed into the value. It's really about future-proofing assets now. It's not just a ticking compliance box exercise.
So have some of your landlord clients, for instance, pushed for more green leases?
Yes, actually, quite recently, I would say, particularly they're more sophisticated or institutional landlords now. We're seeing proper green clauses being built into leases, and things like obligations to share energy data, limits on alterations that might reduce energy, and cooperation clauses around sustainability targets. All of this is becoming more and more common, and landlords are very aware that buildings with poor environmental performance could become difficult to let or refinance. So yeah, absolutely, they're being more proactive in drafting, in the drafting stage at the very outset, rather than reacting later, because it's the world is changing rapidly, and if you get left behind, you get left behind. Especially if you think about what happened with COVID, nobody had imagined that businesses would need to be shut without any fault of their own. And then since then there was a redevelopment, and people started to think more about force majeure, that you have to have different drafting in not just leases but any business contract. So you've really got to be very careful and future-proof these leases.
Okay. 2 more questions for you. On the tenant side of things, Reema, and as with regard to sustainable practices and green leases, on the tenant side, are you seeing that more tenants are having to abide by corporate responsibility objectives as well?
Yeah, that's become really interesting, actually. Larger tenants, especially listed companies or international brands, have internal ESG targets that they have to report on. So they're not just accepting whatever lease is put in front of them anymore. They'll negotiate rights to install more energy efficient systems, request transparency around building performance, and sometimes even avoid properties that don't align with their sustainability commitment, which I think is a great shift. It's not just legal, it's reputational and strategic for them.
Okay, and you just mentioned COVID and the pandemic a few answers ago. This final question is about that time.
Okay.
And the aftermath.
Somebody's thinking like me in this audience.
Great minds and all that. Post-pandemic, have you seen any signs that return to work mandates have increased demand for office premises?
Yeah, it hasn't been a straightforward increase in demand. It's just been more of a shift, I would say. Businesses that are asking people to come back into the office are focusing on better quality working space. They want modern, energy-efficient buildings with good amenities and strong transport links. So, prime office space is still attractive, but older, less efficient buildings have struggled, I would say. It's, you see that when you step out. You just have to go outside and look at some of the shopping centres and how many older retail buildings have closed and, businesses have closed.
Okay.
It's less about more space and more about better space these days.
Okay. Some very good questions, and we encourage more questions to come through from our audiences. You can send those questions through on Hod Jones and Allen Solicitors' social media feed. You can send them through to bilradio@ha.net, or even through the number 03300 294 446. So Reema, if someone is listening to this conversation and thinks their lease is expiring soon, what would you say to them?
Yes, so I would say check whether it's protected, and I can't hone in on that point enough. Check the dates, take advice early. Renewal isn't just about paperwork, it's a strategic moment in your business life cycle.
And if they leave it too late?
Then we have a more stressful and a very different podcast episode.
For sure. Okay. Thanks to our audience member for all the questions. Thank you very much, Reema, as well, and agreeing to answer those questions.
Yeah, well, I would like to say thank you for staying with me, including the surprise live cough that I had. And, I think the proof this is unedited and this is real.
Very much. So, yes, those listening, find out a bit more about Reema. Visit www.ha.net. That's the website for Hod Jones and Allen Solicitors. You could find a lot more about Reema, perhaps to make an inquiry. But if you are listening to this and the subject matter is of relevance to your situation or that of a loved one, then again, please email at bilradio@ha.net, leave a comment on social media, or phone us on 033 00 294 446. This is the Letter of the Law through Bloomsbury Institute London, in conjunction with the London Legal Podcast, as hosted by Hod Jones and Allen Solicitors. Thanks very much for listening. See you next time.